Good evening and welcome to our webinar on why you should register a trust. My name is Panashe Chifamba. I'm a director of tli.global, which acts as a corporate and tax advisory company and forms part of the TLI group. In this webinar, we're going to discuss what a trust is, the structure of a trust, and what the benefits of registering a trust are. As individuals, entrepreneurs, property investors, business owners, and wealth creators, during our lifetimes, we all face certain risks, such as the risk of legal action, business failure, divorce, large tax liabilities, and claims by third parties. For example, in South Africa alone, 70 to 80% of small businesses fail within the first 5 years. For those facing liquidation, up to 98% are stripped of all their assets, resulting from sureties and guarantees signed by a business owner. According to Stats SA, 40% of marriages end within 10 years of marriage. And of course, the most unpleasant statistic of all, the likelihood that you will die is 100%. Clearly, all of us are exposed to a certain amount of risk during our lifetimes. With that in mind, I would like to pose to you the following questions to reflect on as we go through this webinar. If you knew that you were going to die tonight, would your loved ones have enough money to cope financially before and after your estate is finalized? Would there be enough liquidity in your estate to pay the different costs that would arise? Do you know how much estate duty and capital gains tax your estate would pay? Would your family receive what you intended for them to receive? And finally, if your business were to fail, did you risk losing some or all of your personal assets and wealth that you have built? So, what is a trust? Without getting too technical, you can think of a trust in the same way that you think of a company. A company has directors who deal with the management of the company. A company has shareholders who may benefit from the profits that a company makes. A company also has a memorandum of incorporation, which governs how a company operates. And in a similar way, a trust is a founder who creates the trust. A trust is a trustee who administers and manages the trust. A trust is beneficiaries who benefit from the assets in a trust. There are, of course, many differences between a company and a trust, but this is a helpful way of visualizing what a trust is. A trust is created by means of a legal document known as a trust deed. This document contains the instructions regarding management of the trust assets, how the assets are to be distributed from the trust, and further instructions regarding what happens to the trust if the person who created that trust becomes incompetent or dies. A trust is not a juristic person like a company, but it is an entity that is separate from the person who creates it. A trust is not owned by any one person, and so allows the separation of ownership and control and the enjoyment of the asset. A trust can also be described as a legal arrangement, which is created by a person who is the founder by placing assets under the control of another person, known as the trustee, during the founder's lifetime, in which case it would be an inter vivos trust, or on the founder's death, which would be a testamentary trust, for the benefit of third persons known as beneficiaries. The key element of the trust arrangement is the transfer of ownership and control from the founder, who is the person who creates that trust, to one or more trustees who hold the trust assets, not in their personal capacities, but for the benefit of the trust beneficiaries. So the structure of a trust looks something like this. There's a founder, there are trustees and beneficiaries. The founder is the individual who forms the trust in order to transfer ownership of their assets or funds. The trustees are the ones who manage and administer the trust assets on behalf of the beneficiaries. And the beneficiaries are the persons or entities who benefit from the assets or funds. A trust is the entity itself that holds the trust property. So if we look at the parties of a trust closer, starting with the founder. A founder is the person who sets up the trust. There can be more than one founder of a trust. A founder can be any person or persons with contractual capacity whose intention is to dispose of their property to be managed by the trustees by virtue of a trust instrument, which is known as a trust deed. A founder can also be a trustee. They can also be a beneficiary of a trust. However, a founder cannot be the only trustee of a trust. And the reason why this is because a trust is a contract and a person cannot contract with oneself. So if you wish to be the founder, trustee, and beneficiary of that trust, you would then need to appoint an independent trustee to the trust, who is a person or an entity who has no family relation or connection, blood or otherwise, to the trustees, beneficiaries, or founder of the trust, and who is also not a beneficiary of the trust. A trustee, on the other hand, are the persons to whom the trust assets are entrusted. They are appointed by the founder, and they're responsible to ensure that the assets and income of the trust are utilized in accordance with the founder's intention and to the best advantage of the beneficiaries. Any natural person or juristic person can be appointed as a trustee. The trustees have no personal interest or rights in the trust assets. Their role is simply to hold, to administer, and to manage the trust assets for the benefit of the beneficiaries. The rights and powers of the trustees to act on behalf of the trust are set out in the trust deed, which is the constitutional document that determines how uh, the trustees operate and manage the trust. Accordingly, the trustees can only do what the founder empowers and directs them to do. A trustee has a responsibility to the beneficiaries of the trust to exercise their duties and powers with care, diligence, and skill. A trustee can be held accountable should they fail to exercise the necessary care, diligence, and skill. Also, a trustee of a trust may be replaced in terms of the provisions of the trust deed. A trustee may resign, and a new trustee may be appointed in their stead. A trust deed will usually stipulate a minimum amount of trustees required for a trust to operate. In trusts which are considered to be family business trusts, an independent trustee must be appointed. The Master's Office describes a family business trust as one which meets the following three criteria. It has the power to contract with independent third parties, which most trusts will, where the trustees are all beneficiaries and where all the beneficiaries are related to one another. If all these conditions are met, it's considered to be a family business trust and an independent trustee must be appointed. An independent trustee is a person or entity who has no family relation or connection, blood or otherwise, to the trustees, beneficiaries, or founder of the trust, and who is also not the beneficiary of the trust. And the beneficiaries of a trust are the only persons who can ever benefit from a trust. They are appointed by the founder of the trust when he creates the trust and can be amended from time to time. Any natural person can be a beneficiary of a trust, including an unborn. Persons other than natural persons can be beneficiaries of a trust. For example, juristic persons, such as companies or trusts that have already been formed, can also be beneficiaries of other trusts. The founder of a trust may also be a beneficiary of a trust. There is no limit to the number of beneficiaries that a trust can have. Broadly speaking, beneficiaries are usually described as income or capital beneficiaries. Income beneficiaries may benefit from the income generated and distributed by the trust. They have no expectation to benefit from the trust capital, and whether that be a distribution of the actual trust asset or a gain from the realization of that trust asset. And capital beneficiaries, on the other hand, benefit only from the distribution of trust assets, as well as profits from the sale of such assets. So capital beneficiaries will normally receive irregular distributions, and usually when trust assets are sold or when the trust assets are distributed to the beneficiaries. Further, a beneficiary may be vested, which means that they become entitled to the trust income or capital, or they can have discretionary or contingent rights, which means that they have a hope to receive something, which is dependent on the discretion of the trustees. So there are different types of trusts, and trusts are usually classified in terms of the method of formation, and that's whether it's an inter vivos or living trust or a testamentary trust. They're also classified in terms of the rights that are given to the beneficiaries, whether it is a discretionary or vested trust, or it can also be classified by the purposes for which the trust was registered. So, for example, can be a charitable or an employee trust, for example. An inter vivos trust is a trust that is created during a person's lifetime with the purpose of managing certain assets or investments and to support beneficiaries such as family members. These inter vivos trusts or living trusts can be further divided into a vested trust or a discretionary trust, or it can be a combination of both. A discretionary trust is a trust where the trustees will have the discretion to decide whether assets can be distributed to a beneficiary and how much of an income or the assets of the trust is going to be distributed. On the other hand, in vested trusts, the beneficiaries are the owners of the trust assets. The trustees will only have administrative control over the trust assets, which they will manage solely for the benefit of the beneficiaries. An inter vivos trust is ideal for keeping growth assets, such as shares, properties, and other investments out of your estate, and they are an excellent tool to protect your assets. Testamentary trusts, on the other hand, come into existence after the death of the founder and are created by his or her will. Testamentary trusts are especially suited to the protection of the interests of minors and other dependents who are not able to take care of their own affairs. They are created to hold assets on behalf of minor children, since minor children cannot, in terms of our law, inherit. Where there is no trust, assets left by a deceased minor, where there is no trust, assets that are left by a founder to a deceased, to a minor, are sold and the money is paid to them when they reach adulthood. Testamentary trusts are created during the process of winding up a deceased estate. There will be a specific clause within the will of the deceased which directs that a trust must be set up and will serve the same purpose as a trust deed. The testator appoints his or her trustees in their will. Their roles as trustees usually end at a predetermined date or period, such as when a minor reaches the age of 18. The child's guardian does not have to be appointed as a trustee, and in some cases, this can operate as a good check and balance to have a separate and independent person who administers their affairs. It is worth noting that if for any reason a will is invalid, this trust will not come into effect. There is also a special trust, which is a trust whose beneficiary is a minor or an incapacitated person and is taxed as if it were a natural person. A testamentary trust is often a special trust. It is also worth noting that there are other types of trusts, for example, BWIND or business trust, but these fall out of the scope of this webinar. Now we're just going to look at what the benefits of a trust are. One of the most successful investors in the world, Warren Buffett, once famously said, rule number one is never lose money, and rule number two is never forget rule number one. The number one wealth preservation rule is to protect your assets. And most of us will concentrate our time and energy into building up our assets, our income, our earning potential, without ever really considering how to protect those assets once we've accumulated them. We are all exposed to a certain amount of risk in the many roles that we take during our lifetimes, whether that's as a business owner, whether that's as a husband or a wife, whether that's as an investor, a homeowner, It's important to ensure that the wealth and value that we build up and work so hard for is protected against these risks. A trust is one of the best ways to protect and preserve your assets, and it's an excellent estate planning tool. A trust creates the unique position that allows for the separation of assets from the individual's personal estate, and while still allowing a founder and their beneficiaries to benefit and enjoy those assets. A trust will help you separate your assets from any risk that your personal estate may be exposed to, such as property investment debt, sureties, business interests, or any other risk that you may be exposed to. Once all of one's assets have been legitimately transferred to a properly constituted trust, the individual will have divested themselves of the ownership of those assets, yet will benefit from and enjoy the use of those assets held by the trust subject to certain conditions. Assets owned by a trust do not form part of an insolvent estate, and they cannot be attached by their creditors. It is worth noting that the way that the assets are transferred is also relevant when it comes to the extent of their protection. For example, if you transfer an asset on loan account, the amount of that loan account will remain an asset in your estate until the trust fully repays the loan. The implication is that the loan will not be protected from creditors. And if your loan is repayable on demand, depending on the terms of your loan agreement, then your creditors will be able to demand repayment from the trust and subsequently liquidate assets in the trust to ensure that the loan is repaid. So it's very important to also consider how you move your assets into a trust. It is also worth mentioning that upon your death, the assets that the trust owns will not be transferred into your beneficiaries' personal estates, which would be the case if they inherited in terms of a will, for example. This means that these assets will also be protected from their creditors. Another benefit of a trust is the continuity which it provides. A trust is an excellent way to ensure that if something happens to you, your loved ones are taken care of. Upon the death of a person, the assets in their personal estates are frozen and their estate is wound up. This process can be very lengthy, and your dependents may be left cash strapped and unable to receive an income or benefit from your estate until it has been finalized. It is wise to structure your affairs in a way that when you're no longer here, your personal and financial affairs will continue with minimal disruption. Your heirs are usually grieving and traumatized by your departure, and are then doubly traumatized by having to make decisions on matters that they have little to no knowledge of. It may take 2 or more years to finalize an estate, and unfortunately, unexpected events happen all the time, such as COVID-19, and this can delay it even further whilst your estate is frozen, which could lead to real hardship for your family because they cannot access any cash or any assets for their maintenance. Death does not interrupt the operations of a trust. A trust ensures continuity for your loved ones. It will continue to pay benefits to your dependents after you die, and any assets or bank accounts in the trust will not be frozen as part of the winding up of your estate. This means that your dependents will continue to have access to capital and income after your death, which would not be the case if your assets remained in your personal estate. So a trust is also a tool that is excellent at saving on taxes. It's a reason to seriously consider registering a trust. Although tax incentives should not be the primary motivation to register a trust, it is worth noting the benefits that a trust will provide upon the death of its founder. Presently, estate duty is payable on the life assets of an individual at a rate of 20%. Further, death is a capital gains event which triggers capital gains levied at a rate of up to 18%. Moreover, executors' fees are calculated at 3.5% plus VAT of the gross value of your estate, which will be repayable to your executor who assist in winding up your estate. Not to mention the possible transfer and bond cancellation costs that are incurred by an estate where a property is transferred out of the estate to one of your heirs. All told, your personal estate may be exposed to a significant amount of tax and costs. And upon the death of its founder, on the contrary, the assets in a trust are not subject to any estate duty, any capital gains tax, executors' fees, and there are no transfer costs and bond cancellation costs upon your death as a result of the property having to be transferred out of your estate, which could save up to 40% of the wealth that you have worked so hard to build for your loved ones. Another reason to register a trust is succession planning. The founder of a trust can ensure that they preserve their wealth for future generations to come. For example, if the intention of a founder is to retain an asset, such as a holiday home in a prime location or a residential property for their children and grandchildren, a trust ensures that such an asset could be used by the family well into the future and never disposed of. A trust would not only facilitate perpetual succession, it would also allow beneficiaries to have fair access to the property in the long term. A trust is also beneficial for the protection of your minor children. In terms of South African law, a minor cannot inherit as they do not have contractual capacity. Therefore, should a parent die, the assets which are held in the personal estate of that parent are liquidated and the proceeds are invested in the guardian's fund, which is invested conservatively with limited access until that minor reaches the age of 18. A parent or founder who is proactive can ensure that a testamentary or inter vivos trust is created to ensure that their minor children can inherit. Further, should a parent wish to retain an asset such as a property for a minor child, this may be achieved through a trust. Whereas if that property were not in a trust and if it's in your estate, it is liquidated and, as mentioned before, invested with a guardian's fund. Therefore, it loses its nature. So if you want to retain an asset such as a property and you want to pass that on to your child, then it would be wise to transfer such an asset into a trust. It is worth noting, however, that the type of trust that is created for this purpose is important. A testamentary trust, as mentioned before, is created upon the death of an individual, which means that all the costs that we've previously mentioned, the capital gains, estate duty, and executors' fees, will all still be payable before the assets are transferred into the trust. Whereas the assets accumulated in a living or inter vivos trust will not attract any taxes. A trust may also ensure that the surviving spouses, as well as incapacitated or special needs beneficiaries, are taken care of. Setting up a trust for special needs or incapacitated persons allows for the safe custody of assets and at the same time makes sense from a tax perspective. Other considerations to take into account and benefits of a trust is the ownership of assets. Some assets are not capable of being divided and shared amongst your heirs or loved ones. For example, business or farms or other property. By transferring these types of assets into a trust, your heirs can be beneficiary of the income generated by those assets. The heirs are also protected from each other's creditors, as well as potential claims by spouses upon divorce or potential claims of creditors on sequestration of one heir. A trust will therefore ensure that the value you build up in your lifetime is retained for your heirs. A trust is also beneficial from a confidentiality perspective. A will and a liquidation and distribution account, which must be drafted in the process of winding up your estate, become a public document on your death. A trust, on the other hand, does not form part of an estate, and therefore the list of assets held in a trust remain confidential. Most of us will work very hard and diligently to build up our wealth and spend many hours considering investment strategies and opportunities, but neglect the number one rule of wealth preservation. An essential part of building your wealth is protecting and preserving it. A trust is one of the most comprehensive estate planning tools, and it can ensure the fruits of your labor are retained and enjoyed by your loved ones. However, it is critical that you engage the services of an experienced professional, as the incorrect structuring of your estate and drafting of your trust deed may spell disaster. A trust must be properly constituted in terms of the applicable laws and your affairs structured in a way that reduces your tax exposure. Failure to do so may lead to your creditors being able to attach the assets in the trust and may leave you exposed to significant tax liability. So that concludes our webinar. I want to thank you all once again for joining us this evening. And should you wish to register your own trust and an estate plan that is tailored to your specific needs, please feel free to get in touch with one of us on the contact details provided or through our social media pages. Please also note that we'll be offering a free 20 minutes virtual consultation for those who may be interested in registering a trust.